start the first afternoon panel. Before we get into the discussion of the panel, which will be about competition, collective actions, and class actions, apropos of nothing, I'm an environmentalist, and I feel that wolves have been unfairly maligned at this conference. Wolves, in fact, are majestic creatures. They are intelligent, they're strong, and they are effective. And importantly, they work together and collectively to bring down giants. And so those wolves need fangs because their prey is dangerous and destructive. And so I just wanted to put in a word for the wolves, apropos of nothing. Don't be afraid of wolves. They're important creatures in our ecosystem. All right. This panel will be comparing and contrasting collective actions in a variety of jurisdictions relating to competition claims on behalf of injured consumers and workers. The focus will be on the jurisdictions of our panelists from the UK, the US, the EU, and Israel. Just to set the stage for a moment, competition claims raise interesting questions for private adjudication and group litigation in particular. Cartels and abuse of dominance or monopoly power can have devastating effects on economic growth, innovation, consumer welfare, employee pay, and more. Violations of competition laws are often well suited for collective actions. And this is because anti-competitive conduct can have widespread and rippling effects on economic markets, raising prices by purchasers across markets and across all levels of distribution chains, and potentially suppressing wages across labor markets. But these collective antitrust or competition claims also raise thorny and difficult issues involving the measure of damages and the means by which these claims should be aggregated. So this panel will discuss some of the procedural and substantive issues involved with adjudicating collective private antitrust claims on behalf of injured consumers and employees. Who can recover? How are claims initiated and aggregated? What is the measure of a claimant's damages? What is the purpose of the action? Deterrence, compensation, or both? And we'll compare and contrast how these four different jurisdictions answer some of these questions. And we may close with a discussion from the panelists about which systems work best, or which aspects of which systems work best to achieve the values behind a collective action system for competition cases, deterrence of anti-competitive conduct, and then compensation of injured victims. So what we're going to do is we're going to have a discussion, and we're going to walk through a case from initiation, how our claims initiated, then talk about how our claims are aggregated, then talk about this thorny issue of measure of damages, and then skip to how claims are litigated, and if we have time, we'll talk a little bit about distribution, how settlements or judgments are distributed to injured victims. So let's start with initiation, and I'll start with Roger. Well, first let me introduce the panelists. I haven't done that yet. We have four excellent panelists. They're all competition lawyers. They're all men. They all have blue eyes. Roger Burnett, he joined us. He just found out about this, I think, on maybe Tuesday or Wednesday, and we welcome him and we thank him for joining at the last minute. He practices commercial litigation in the UK, in London, first as a barrister and then as a solicitor. He was at Baker & McKenzie in Hausfeld and recently founded a firm called Charles Linden. Roger has acted in a number of large follow-on competition damages claims before the courts of England and Wales. Then we have Joseph Saveri over here. Mr. Saveri is an antitrust and class action lawyer in the US. He founded his own firm in 2012, and that firm has grown in 7 short years to be a powerhouse in leading significant antitrust and other class actions in the United States. We have Dr. Till Schreiber from Brussels. He's a competition lawyer who is now the managing director of an organization that analyzes, prepares, manages, funds, and settles large antitrust damages claims in Europe. And last but not least, we have Yuri Sorek. He's a commercial litigator in Israel at Agmon and Company, with a focus, unlike the other panelists, on defense work, including in antitrust and class action cases. So that's the panel. We're going to try to have a discussion, and we're going to start with Roger and ask him the initial question. Who makes a decision to bring, and you can answer all or any of these claims about claims administration, and why don't you do it from your seat? If you pass him a microphone. Okay, good. So the questions are, who makes the decision in the UK to bring a claim, an antitrust claim, a lawyer or a consumer group? And if so, what kind of group? Does an aggrieved client bring the claim? What is the process pre-initial filing of a complaint? Is there a book build? What is a book build? Is a claims aggregation process, does that happen before the filing or after? So Roger, why don't you start?
Thank you. So I think the question of claim initiation is very interesting. And I see a distinction between the entity or person who decides to bring the claim and also the, how the claim is initiated. So in the UK, you can get individuals or you can get corporates who take the decision to bring a claim. In relation to, you've also got the Consumer Association, also known as WICH, and they can bring representative actions on behalf of consumers. Finally, in collective actions, you can set up special purpose vehicles. You can get a class representative. That class representative doesn't need to be a member of the affected class, and he can basically bring a claim on behalf of the class members. But equally, the class representative doesn't need to be a private individual. It could be a corporate entity, or it could be a special purpose vehicle. So I think you sort of talked about whether or not lawyers could bring a claim. I think technically the answer is yes, but according to the CAT guidelines, there might be issues about conflict of interest if lawyers were seen to basically be driving the special purpose vehicle. So that's who can take the decision to bring a claim. But what I think is really interesting is looking at who initiates the claim in the sort of broader context. And I think in the UK there's been a bit of an evolution. So going back, say, 20, 25 years, lawyers would typically wait for a client to walk in the door and say, I think I've got a claim, I think I've got a competition claim, and then they would act for that individual or for that company. Then in around 2003, when commission decisions, the EU commission decisions, were binding on the courts of the UK, there was a change, a sea change, and claimant firms came in first from America, where I think this process had been going on for a number of years, and they would sit down, create a spreadsheet with pretty much every single infringement decision that the EU Commission had made. They would look at the infringement period, they would look at the geographical area, they would look at the cartellists, they would look at the fine, they would look at any limitation issues, and then they would, I sort of see it as claim mining, they would work out which of those decisions they thought were worth bringing a follow-on damages action in relation to. And then the lawyers would go out and actively seek claimants. So I think we're now potentially entering a third phase, and that is where the lawyers themselves initiate the claims. And the reason why I think we're coming up to a third phase is, one, the first point is that pretty much all of these commission decisions, the historic decisions, will have been mined. There will be new commission decisions coming through, but there won't be that many in any given year. Secondly, and particularly important for people in the UK, we've got the looming issue of Brexit, which may make cartel follow-on damages claims incredibly difficult to bring. I believe that following Brexit, at the moment, as it's planned, commission decisions will not be automatically binding on national courts, so that will make it difficult. In addition, commission decisions are becoming more and more redacted, so the information that you have in order to bring a follow-on damages follow-on damages claim is limited. And finally, in addition to all of those, the space is becoming more and more crowded. Sorry, I apologize if everyone's missed all of that.
Why don't you repeat everything you just said?
At least you heard me. Sorry, I don't plan on repeating everything. So the space, I believe, now is becoming a lot more crowded. So initially, you had people like Hasfeld who were doing this, and then Quinn Emanuel, and then a lot of people have seen that this is a potentially lucrative area to get into. So the space is becoming a bit more crowded, and so I think people are looking to do different things. So I think people are now looking to build, they're actually looking for the infringements themselves and looking to build standalone claims, whether that's building standalone claims right from the outset, or whether it's quasi-standalone claims, where there hasn't been a commission decision, but there's been an announcement that there is an investigation, and then people will jump onto that and bring a claim before the decision. So I think initiation is an incredibly interesting area with regard to class actions in the competition space. And I'll now pass on.
Thank you, Roger. So why don't we'll skip Yuri since you have a presentation. We'll do you last.
Yeah, maybe I'll just, if you do this one, I'll just answer.
Okay, go ahead.
So, good afternoon, everybody. I'm a defense lawyer, so of course, legal proceedings are initiated against my clients. They don't choose to be there. The observations I can make about how the proceedings really are initiated are that most of the time, the guy who really makes the effort, who comes with the idea, is the lawyer. And there is a Supreme Court ruling in Israel that, unlike the regular rules of ethics, allowed solicitation in class actions in general, and which also applies to competition cases. The named plaintiff usually is an injured entity. It can be an individual, it can be a firm. Sometimes, quite rarely, we have NGOs. Usually when we do have NGO, they come together with an injured entity because the criteria to approve an NGO as a named plaintiff are somewhat more strict than to certify an injured entity. So these are the general ideas. We know that lawyers, if I get Roger's last comment, lawyers themselves personally usually are not the named plaintiffs. There are some rulings which rejected this option, but I think it's someone told me in the break. It's a hidden secret. It's well known that what motivates and what brings action are the lawyers and not the named plaintiffs.
Do you know whether the NGO or client will first come to the lawyer, or whether the lawyer will then search for a client in an NGO? Do you have an idea about how that works?
Well, again, first we know that the Supreme Court did approve solicitation, so we know that sometimes the lawyers go and chase after clients. Second comment is that we have some serial claimants. They have the property of being injured by any cartel, be it in Israel or abroad. They are always feel themselves injured. And there are collaborations between specific lawyers and specific named plaintiffs, and they go together. We know the names. I mean, there are not that many of them. So in these cases, I cannot say who told who first, because they come together.
All right, thank you. Joe, how about the United States?
So the initiation part of a class action in the United States is actually is complicated, and there are a lot of very key decisions that American class action lawyers, particularly in the antitrust space, have to confront and sort through at the very beginning of the case. One of the first things is that in the United States, depending, and this varies by state, there are ethical rules that limit the solicitation of lawyers for clients. There are old rules that go by old English names like Champerty and Barratry, and so there are there are ethical reasons why lawyers can't reach out and essentially solicit clients. So that there's a series of ethical concerns or landmines that American lawyers have to be concerned with. I think the other thing that's perhaps different about at least my practice is how much investigatory work we put into identifying cases. There are lots of reasons why it's in the interest of the lawyers to be first to file cases. We spend a lot of time and resources on investigation. This includes work, and we've been able to be quite good at it to identify, even though it's not necessarily public information, which companies are subject to, for example, criminal cartel enforcement in the United States. We've been able over the years to identify before there's public information that a grand jury has been convened or someone's been indicted, that there is an investigation, government investigation regarding the, a certain industry or companies. So we spend a lot of time doing that, figuring that out. Also, because I'm an antitrust lawyer and other people know I'm an antitrust lawyer, we get a fair amount of inquiries just kind of coming in from other lawyers or people who have been affected by some kind of injury into our office, and we investigate those inquiries. A lot of them turn out to be things that are either not suitable as antitrust claims or not suitable as class actions. But we do spend a lot of time screening and identifying potential claims. Now, once we've identified viable claims, antitrust claims, what we have to think about are issues that really arise out of the substantive antitrust law of the United States. In particular, we have a system, a federal system of antitrust laws as well as a state system of antitrust laws. And that's important for a couple of key reasons. In the United States, it's only the direct purchaser that has a damage claim. That is the entity or persons who purchase directly from the companies or the people that have been engaged in the antitrust activity. So, and of course, in every case other than a consumer case, there is usually a chain of distribution, and the products find their way throughout the U.S. economy. Those claims by purchasers who are not the first level of purchaser are called indirect claims because they're not direct claims, and the damage claims arise from the substantive law of a number of states. Not each state has those rules, and right now there's about 30 states in the United States to permit these indirect purchaser damage claims. Some of the big states like Texas don't have these indirect purchaser claims. So there are a significant number of injured parties in the United States by an antitrust violation who simply have no substantive law claim. So one of the and in the United States, because of the way Rule 23, our class action law works, and the way the case law has developed over time, lawyers and class representatives cannot represent the entirety of the group of purchasers. So, for example, individual plaintiffs have to represent one level of distribution, and lawyers have to represent one level of distribution.
Joe, how do you decide as a lawyer who you want to represent? the direct purchaser, or a series of indirect purchasers?
So I think that, there are lots of different views about that. I mean, part of it is dictated by who your client is, right? Obviously, I mean, who's walked in the door. I think from our perspective, there are advantages and disadvantages to to deciding who, if you have a choice, who you want to represent. The direct purchaser claim is more easy to prove. The damage modeling is easier. The class certification law is more in favor of class certification. On the other hand, the indirect purchaser claims, while there are many more purchasers, they are harder to prove, and the class certification law, as it has developed recently, has become less favorable, in particular for indirect purchasers.
Okay, thanks, Joe. And we're gonna talk a little bit more about this issue of how you measure damages in antitrust collective actions. But why don't we pass the mic over to Till, and why don't you talk about how claims are initiated in the EU?
Yeah, if I'm talking about the EU, we just learned this morning that it's not at the EU law level, but at national level that there are actions. We've heard that unfortunately there are also no consumer claims in EU or at a national level in Europe regarding competition infringements, but there has been a strong increase of damage actions across the EU in national courts, mainly in several jurisdictions, being the Netherlands, Germany, Finland, and Austria. That's the key jurisdictions where you have most cases being brought, and in the meantime also a quite large number of cases adjudicated, and therefore quite fruitful case law. While there are no collective actions in the formal procedural sense, there are collective actions in form of a so-called bundling or assignment model that basically consists of victims, corporate victims of antitrust infringements, transferring their claims to a specialized entity which is analyzing, I would say, the best placed jurisdiction to bring a claim, and then enforces the action in its own name, on its own risk, and also funding the action on its own risk, and then brings one single action in which it enforces all claims assigned to the specific entity. And that has been a bit of a game changer, and we see that model being applied in many jurisdictions on continental Europe. In the UK it has not yet been tested, maybe because you have other group actions, etc., so that there's no need for such an assignment model. However, this has in the meantime been a quite established and effective mechanism.
Till, let me ask you a question about the SPV. How does the SPV to whom people are assigning claims, consumers are assigning claims, decide whether or not to bring a case in the first place?
That's a bit of a similar process that we just heard from the US. It's really a careful analysis of existing infringement decisions, so basically follow-up situation to competition infringement decisions either by the European Commission or national competition authorities. But there are, this model is not only being used in the field of antitrust in the meantime, but there are increasing efforts to apply the same mechanism in, for example, security actions as well. So it's basically ex ante risk assessment by the SPV. You need specific know-how. You need to know, of course, the risks involved in such litigation. You should know quite well the damage that is in play. So it requires a lot of upfront investigation.
And who funds the SPV?
That can be the SPV. If you are, I can talk about us, for example. We've been bit at the forefront developing this model. In the beginning, it was really persons who invested private monies. In the meantime, there can be external funders who participate in such actions, or you fund it because you had success in other cases.
So there can either be third-party funding, or the SPV can have its own capital. And
Exactly.
the reason why people fund it or have its own capital is they can get a success fee at the end. Is that right?
Typically, it works that because you bring the action in your own name on your own risk, and in your own name means that you're owner of the claim, you are 100% owner of the outcome, and then pay out a certain share, typically around 70%, to the injured company that transferred the claim.
So by contract, there's an assignment.
Yep.
They agree to give the SPV 30%, and they get 70% in the event of success.
Yeah, it's regulated in a so-called purchase agreement or claims purchase agreement, and there you can regulate things like the payout in case of success, etc.
So how do you find the consumers that aggregate or assign claims to you? How does that happen?
Yeah, you have to speak. In the beginning, it was really something you had to preach to companies that they actually have a claim, or potentially at least. Companies were not aware that they could claim for damages. That has very much changed, and I think there's two elements which play a key role. First of all, there have been some companies, private companies, or even public companies, like in Germany, for example, the German railway, that have taken a very active role in claiming damages. They have a policy of claiming damages against suppliers who have been involved in cartels, and they have even a large in-house team. And because they were successful, other companies also said, okay, why don't I do it? And started as well. And of course, at EU level, you now have the directive which entered into force, which has been implemented into all member states, the so-called damages directive. So there's certain rules which have been harmonized across the EU. For example, limitation periods, the question of joint and several liability, presumption of harm, so quite fundamental aspects which have been harmonized and which result in a situation that at least corporate victims are generally nowadays aware that they may have a compensation claim and are much more actively pursuing those claims.
All right, thank you. Let's go back to Roger and talk now about aggregation. What is the process in the UK by which antitrust claims get aggregated? Is there a class procedure, and if so, how does it work? Is it opt-in? Is it opt-out? Is there some other means of aggregating claims? Roger?
So I think the answer to that really depends on, as you sort of alluded to, there are a number of different ways in the UK that you can have multi-claimant competition actions. So you could have a situation whereby you have a claim, single claim form with a number of claimants. You could have what's called a group litigation order. You could have a representative action, or you could have a collective proceedings order application. And the opt-out version of the last one is the closest thing that we have to the American class action. But that collective proceedings order application, it can be both, that system can be both opt-out and opt-in. So obviously with an opt-out system, like once the case is certified, all those people who satisfy the definition of the class would automatically be deemed to be part of the proceedings until such time as they opted out. And in the event of any judgment, the judgment would be binding upon all members of all UK domiciled class members, unless they opted out of the of the action within the time set by the Competition Appeal Tribunal. And then the reverse is non-UK domiciled people, if they wanted to be a member of the class in sort of opt-out proceedings, would have to opt in within the time limit that the Competition Appeal Tribunal had set down.
Under the opt-out method that the UK has, how many classes or groups have been certified?
At present, it's a very new regime, so there have only actually been 2 cases that have got to the certification hearing. The first was in relation to mobility scooters, which it was a follow-on case, following on from a decision of the OFT, and it wasn't that wasn't certified. The class representative was asked to go away and reformulate the claim, and I understand that when they went away and looked at reformulating the claim, they took the commercial decision that it was no longer commercially viable, and so they didn't proceed with it. But it wasn't actually refused certification. And then the second case that went all the way to certification was the case of Walter Merrick's about master change interchange fees, and that wasn't certified. And the Competition Appeal Tribunal basically said that the way that the class action, or the way that the collective proceedings order application was formulated, meant that there was absolutely no way that they could be certain that it satisfied the compensatory nature of damages within the United Kingdom, because they just couldn't tell whether the entitlement of any single individual. That has now been appealed, and the Court of Appeal has heard the appeal, and we're waiting to find out what happens next. There are a couple of other claims in the pipeline in relation to trucks, but they haven't reached the certification hearing just yet.
So the answer to my question is 0. There have been 0 groups or classes certified in the opt-out procedure in the UK.
Correct, but we're hopeful.
All right. All right, Yuri, what's the process by which claims are aggregated in Israel, and how does that process work?
Well, that is quite easy. We have an opt-out system. The court has the authority to reverse it into an opt-in mechanism. Sorry, but it was hardly ever done. Definitely not in competition cases. We don't have 0 cases, but we do not have that many competition cases that survived certification process. So I don't have good statistics about it. Most of the claims were either denied or settled or approved at the lower court, but then the result was reversed by the Supreme Court. So we're still waiting, but if I'm talking about the general class action rules, then it's an almost absolute opt-out system.
All right, thank you. Joe, what is the process by which claims are aggregated in the United States?
So under Rule 23, in these antitrust damages claims, we have an opt-out model. So after we have submitted the matter for determination of a class to the court, and the court agrees, notice will go out to the class members in various forms, and they have an opportunity to opt out. And if class members don't opt out, they are bound by the judgment in the case. I guess one thing I would note is that one of the things that has happened is that the determination of class has now been delayed substantially in the case. There was a time when the class determination was to be made as early as practicable in cases, and so that meant that it happened very quickly and notice went out. That had the advantage of making the class very cohesive. One of the phenomenon now is, particularly with the delay in class determination, there are a number of law firms whose business model is to solicit entities to opt out from classes. And that process starts almost, well, it usually starts after the class action lawyers file the cases because, to my mind, we do the hard work of determining a case. But there is a group of law firms and organizations that solicit either class members to either opt out or to file claims. And so there's another kind of mode of collecting or aggregating those claims, which has a number of problems as we go through the class action, which maybe we'll talk about.
Okay, thank you. Is one of the reasons that class certification in the United States, especially in antitrust cases, but probably in other cases, has moved towards the end of a case, or certainly not at the beginning anymore, because merits are more of a consideration at the class certification stage? And I'll just preface that by saying, I think there was an allusion earlier in the conference to, I think it was the Merrick's case, where the court in the UK denied certification because the court seemed to be requiring that the class or the lawyers have a full-blown model of damages and a full-blown method to distribute damages to the class members at the class certification stage. And so that seemed to be an impossible requirement to meet early on in a case. And I think what's happened in the United States, and Joe, I'd like you to comment on this, is the US courts have seen the same thing and resolved that question by saying, yes, we will require the plaintiffs to have a full-blown model capable of proving that everybody was harmed and capable of showing damages and capable potentially of distributing the damages to class members. We'll make that a requirement of class certification, but we'll just push class now to the end of the case rather than the beginning.
So the answer to that question is yes.
Yeah. Was that a leading question?
Or perhaps a rhetorical question, or a combination of both. I mean, that's clearly what's happened. I think that there's been there's certainly been the case that the burden on the plaintiffs for determining or for showing that a class action is appropriate has increased. I think a lot of the confusion is about what that really means and how much of a determination on the merits is required and how much actual finding a fact which is close to what or what the jury will actually be asked to do at the trial is required. That is a place where there's significant confusion, and that's one of the places where a lot of the action and heat is generated in American class action practice right now.
That's right. Till, how are claims aggregated in the EU or in your practice?
Yeah, I mean, as said, there's no experience with opt-out actions at national or EU level. So in this case of, I call it the aggregation of claims by companies which are harmed by the same anti-competitive conduct, typically what courts require is that you have to substantiate that each of the individual companies that is transferring the claims to the claimant has to be affected by the anti-competitive conduct. So you typically need to specify not only the individual victims, but also the way that the individual victim is harmed by the infringement, which is also the result of a more scrutiny by national courts, maybe as a result of some developments which took place where in some cases in the UK, but also in the Netherlands, it was tried to have a very large group of affected companies. Allegedly, I don't know, there was one case where allegedly 65,000 Chinese companies were harmed by the cargo cartel, and it turned out that these companies didn't even know they are part of a proceeding in London or in the Netherlands, and so the case was denied, and that resulted, however, in a situation where courts are now more cautious and ask for more evidence up front. And although the damages directive has a presumption of harm, so that if you have an infringement established by the European Commission or National Competition Authority, there should be a presumption of harm. However, it's rebuttable, which means that you have more economic arguments coming up relatively early in the proceedings, because defendants tend to argue that cartels don't have any effects, of course.
So there's a presumption that a cartel will have affected the purchasers of a cartelized product, is that right?
Yeah, that's correct.
That's correct. And let me ask that for each of the panelists. Is there a presumption of harm to injured or to purchasers who bought price-fixed products in the UK?
Correct, yes, under the implementation of the damages directive.
And what about Israel?
No, there's no presumption of damages. The decision by the Israeli Competition Authority can be served as a rebuttable presumption for the existence of the cartel. We have some cases which were not decided where Israeli class action was brought based on European or American decisions, and then the question is more complex. To what degree do we allow, can plaintiff or petitioner rely on foreign decisions with regard to the existence of the cartel, and of course to the existence of any damages? It was not decided yet. Strictly speaking, a foreign decision is not even admissible as evidence, but because the certification stage, everything is a little bit more loose than there are many more than one cases where plaintiffs try to rely on foreign decisions.
Joe, if in a U.S. class action, is there a presumption that if there's a cartel or an allegation of a cartel at the class stage, that class members are harmed?
So I think the answer to that is yes, okay? And the reason is because there's a line of cases that goes back probably 50 years that stands for that very simple and I think common sense proposition. Having said that, given the way the law has developed, it's been an awful long time since I've been in a case where the plaintiffs have only relied on that presumption. That presumption is a starting point for the proof we submit to show, consistent with what the applicable class certification standards are, that in fact the cartel, which for class certification purposes is generally presumed to have happened, did in fact cause damage or in our words, constitute impact for the class.
So let's now move to what I think is one of the thorniest questions in antitrust class actions or collective actions, and that is, what is the measure of harm or measure of damages to injured consumers or purchasers or workers? And I think what a court system or jurisdiction decides as the measure of damages really relates in part to the purpose of the enterprise. So in the US, it's relatively well settled that private actions are part of the regulatory system, and thus that private lawyers can be considered private attorneys general, seeking not only compensation for victims, but also to deter wrongdoing. So the US Supreme Court has found that under federal antitrust laws, Joe alluded to earlier in the United States, 100% of the claim for any overcharge to a purchaser caused by a price fix or abuse of dominance goes to the first purchaser. And the rest of the purchasers in the chain of distribution under federal law have no claim, or no claim for damages. The pass on, that it was passed on, is not a defense. That they passed on the overcharge down the chain of distribution is not a defense. And the part of the basis of that ruling is that it would make prosecuting claims easier and place the incentive to bring the claims in the hands of the entities believed by the Supreme Court in the Illinois Brick decision most likely to bring them. But this practice in the United States, resolving this question of who owns the claim, at least under US federal antitrust law, raises at least two problems. It provides a windfall, or potential windfall, to the direct buyers who may very well pass on the overcharge. I'm a wholesaler, I buy a product that was inflated, I sell it at an inflated price, so I'm passing along the overcharge, and yet under US federal antitrust law, I can recover 100% of the amount I overpaid for this product. And so this blocks others in the chain of distribution from recovery. Though caveat, as Joe mentioned, under US state law, or laws of several states, indirect purchasers can recover. In other jurisdictions, where private lawyers, the wolves, are not being incentivized to bring claims in order to deter violations, they're bringing claims for compensation. The pass-on appears to be a recognized offense. So I'd like to talk a little bit about that and what the problems are once you recognize the pass-on as a defense. Because what we saw in the Merrick's case, this case that Roger described, where this is a class action against MasterCard for fixing the interchange fee, causing the fees paid by merchants to rise. And this was a case brought by a purported class, a purported group of every single human being in the UK who bought anything from anywhere. And because under the theory being that the merchants pass on the overcharge to the consumers who buy stuff in their stores. And even if you buy using cash, the stores that don't accept MasterCard and Visa are pricing higher under the umbrella of the cartel caused by MasterCard. And so if you don't have the direct purchaser rule, it seems to me, you end up with this diffusion problem where the damages are so diffuse and so hard to quantify that you may not be able to recover at all. So with that overview, Roger, how is this issue handled in the UK, and what's your view of it?
So in the UK, I think the question was, what's the general measure of damages? If we start with that. So the general measure of damages in the UK is compensatory. It's meant to put the claimant in the position that they would have been but for the abuse. So if you look at a typical cartel price fixing claim, then you have the sort of 4 key components. So the first component is let's look at the value of commerce. So there could be £100 million worth of widgets. Then you're looking at the amount of the overcharge because of the cartel. Then you're looking at the extent to which the overcharge was passed on. And then finally, you're looking at interest. And so if we now sort of zone in on the pass-on defense, following the implementation of the damages directive and also following on from a decision in the Competition Appeal Tribunal and also the Court of Appeal from the same decision, excuse me, it's been decided that it's not really a defense. It's really about the quantification of damages, and it's basically making sure that a claimant isn't overcompensated and that a defendant isn't paying twice for the same overcharge. So in your case, you have a direct purchaser, and let's say the price of the product was £100 and the overcharge is 10%, then you need to look at pass-on, because you can't have 10% sitting with the claimant when actually he's passed on 50%. So it's really about where the damages sit and making sure that claimants don't over-recover and the defendants don't double pay. So after the damages directive in these cases, it's up to the defendants to raise the so-called defense of pass-on. And in relation to indirect purchasers, then there's a rebuttable presumption that the overcharge has been passed on to them. So in terms of what you were saying about everything just being a bit too diffuse and a bit too complicated, I think the way around that is active case management. So the Competition Appeal Tribunal is now the forum of choice for competition claims in the UK. And if you can basically bring the direct purchaser claims and you can have the indirect purchaser claims, and to the extent that there are end purchaser claims and they're all heard and case managed together, then that is a practicable way of managing that pass-on issue. So everything's dealt with in the same hearing, and you can work out where the loss sits at each stage of the distribution chain.
Okay, thank you. Yuri, how does that work in Israel?
First of all, there is no binding precedence to answer these questions. There are some district court rulings, and there is a general attorney's opinion which favored the acknowledgement of the pass-on defense. So presumably, we do have pass-on defense, which makes things only more complicated, because then we indeed get into the question of how should we divide the damage between the different layers or along the chain of purchase. I think we have to make a distinction between cartel cases and monopoly cases. Cartel cases are somewhat easier conceptually because we know that cartel is illegal, so every dollar, every shekel, every euro, the cartel overcharged should be compensated for. There are practical questions of how can we know what's an overcharge. If we can draw the line, then we know that everything above that line should be compensated for. Monopoly cases are more difficult because we don't have a line. We know monopolies are not illegal. Monopolies are even sometimes we want to have monopolies. And the legal system here acknowledges that monopolies are allowed to price the goods in somewhat over-competitively, in an over-competitive level. So the question is, how over-competitive? And I think this is a question that both the Europeans and Israel struggle with. The Americans, I don't think you are struggling with it because I don't think monopolies, I don't know, are just allowed to price the goods whatever price they like, and if I'm not wrong. But in Europe, I know we tried to compare ourselves to Europe to bring some notions or some ideas from Europe. I'm not familiar with any analytical, theoretical basis that can justify where should we draw the line and start compensation.
All right, Joe, do you want to add anything to how the United States deals with the pass-on issues?
I'm not going to, I think you covered it, and
Okay.
there's probably more to talk about. Although we do...
Joe, turn the microphone on.
Can you hear me? Yeah. So it's interesting you say that. Eric, we do Section 2 monopoly cases too. And in the United States, the methodology we use for determining damages is essentially the same as that we use in a cartel case. We try to figure out what the prices would have been if not for the anti-competitive activity, and that's the measure of damages.
Till?
At the EU level, I mean, there has been the damages directive which harmonized many of these aspects. Typically, you can claim for the cartel-related overcharge, then minus the pass-on. Pass-on is recognized, which also results in a standing of the indirect purchaser. So this is also confirmed by ECJ case law. Basically, everybody who has been harmed, irrespective of the place in the supply chain, has a right to claim for damages. However, if you argue a pass-on, there is a risk that the pass-on results in volume effects. So volume effects is also an additional damage that you can claim for, plus interest at the end, and interest is accruing as of the day that the damage occurred. So typically,
By volume effects, do you mean that when the prices are higher, people sell less, and that's,
Exactly.
that's
Yeah,
damages?
yeah. It's
So
an additional-
you can recover for that in the EU.
Exactly, you can recover from that, and sometimes, depending on the market, the volume effects can be very substantial, so that any pass-on loss or from the
Right,
German
because
perspective
the way
is
the direct
offset.
purchasers tend to be injured is that when the price is higher, they sell fewer products.
Exactly. Yeah.
And so that's really how direct purchasers are injured.
Yeah. Just from a technical side, it's maybe interesting because the directive foresees for the presumption of harm that there is a damage, and it also foresees for the pass-on in case an indirect purchaser claims. So you have the situation foreseen by the directive that indirect and direct purchasers may claim for the same damage. But then the directive does not give any way of how to solve this mess, especially in cross-border cases, when you imagine that for a pan-European cartel you have claims pending in up to 27, 28 jurisdictions for the same infringement from various supply chain levels. How can you take into account what is happening in other jurisdictions? So that will be really key for national courts or to somehow find a solution to deal with these parallel actions. And in practice, what happened is that national courts tend to be quite cautious about the pass-on defense, and they make a distinction on the one hand side between more legal arguments versus economic arguments. So even if they are convinced that a certain part of the damage has been passed on to the next level of the supply chain, they tend not to grant the defense in case further down the supply chain is no damage being claimed, because otherwise the argument, and that's a legal argument basically, would be that, or the situation would be that the illegal gain would be kept by the infringer, and that should be avoided.
So let me ask, Joe, you can comment, but before you, go ahead.
Yeah, I just had one thing. One of the things that happens in the United States is we actually try these cases to juries. And usually the direct and the indirect purchasers are tried to the jury at the same time. And we ask the jury in the United States to do the kind of calculation and sorting through who has what overcharge as part of their deliberations. And as a plaintiff's lawyer, one of the things we think about all the time is whether the jury is going to figure out, despite what the court tells the jury about the law, that in fact the direct purchaser didn't lose any money on these overcharges. And so another problem and difficulty with this law is how it manifests itself in proof at trial and jury deliberations.
Well, we only have a couple more minutes. I just wanted to ask one additional question about a certain group of people who are injured by anti-competitive conduct, and those are workers. Market concentration, market dominance has led to suppression of wages across Europe and in the United States and across the world. And I'm wondering whether the class or collective action process under competition law in any of the jurisdictions allows for workers to claim for violations of competition laws in addition to consumers. So Joe, why don't you go first here?
Yeah, and let me just jump in briefly on that. We have in the United States now a number of significant cases involving labor markets and agreements that have to do with agreements among competitors not to recruit or to poach each other's employees. These agreements are agreements between competitors. What's different about these agreements is they are agreements among buyers, that is, consumers of labor, as opposed to sellers of products. The short answer to your question is yes, the class action device works. Classes have been certified. There are additional complexities associated with labor markets and proving damages by buyers as opposed to sellers, but this is a developing area of United States class action antitrust law.
Does anybody else want to address that question? Or do workers bring competition claims in any of these jurisdictions? Yuri?
Well, it's not workers. I'm not familiar with any workers, but we did have another maybe bypass of competition where actions were brought as securities class actions, arguing that a public company did not disclose that it was a party to a illegal competition practice, that it was not a party to a cartel or something, which is maybe sounding absurd. Usually when you do a cartel, you don't go and tell the whole world about it. But theoretically, you can think of this ground for an action.
Roger, have workers brought any competition claims in the UK?
I've got to hold my hands up and say I just don't know the answer to that.
Okay. Till?
Yeah, same here. I'm not aware of any concrete case, but in theory, Manfredi says everybody who is harmed can bring an action and has a right for compensation. So if you can show that you have been harmed as a worker because of an anti-competitive non-poaching agreement, then you have the right to bring such action.
So workers of the world should unite and bring competition claims. All right, does anybody have any other further comments? We have a couple of other minutes, and if anybody has anything else they want to say, are there any questions from the audience? All right, we're done. Thank you.